Swayam Prabha. Digital India. Educated India.
Good day everyone and a warm welcome to all our viewers. I'm delighted to have you join us for this engaging and enlightening journey into the world of jurisprudence. I am Dr. Simranjeet Kaur, Professor and Principal School of Law, City University, Ludhiana. In today's lecture, we will discuss the rule of recognition and emergence of the legal system. So let's embark on this intellectual journey together and uncover the fascinating world of legal theory. So let's start with the topic. The concept of law, according to the heart, is a system of rules, and the rules are the sole basis of a legal system. According to the heart, legal system is nothing but a combination of primary and secondary rules. Rule of recognition is kind of secondary rule which validates a legal system and which is central, foundational and essential to every legal system. But this view of the heart has been criticized by the other legal positivists like Joseph Raz, Ronald Dworkin, John Finnis, and they have pointed out some lacunas in the heart's doctrine, as well as they raised some valid question which is also necessary to be considered. Hart describes rule of recognition as a foundation of the legal system. In this lecture, my objective is to find out is the rule of recognition exist in the modern legal system, as well as can it be the foundation of the legal system. To fulfill this objective, firstly, I dealt with the evolution of the rule of recognition and then Hart's opinion regarding this, and later on I briefly discuss the objections raised regarding the Hart's doctrine, and finally I make a conclusion with the modification of that doctrine which may be applicable in the modern legal system. Now let's discuss what Hart says about evolution of the rule of recognition. H.L.A. Hart was considered as one of the great legal positivists in the theory of analytical positivist jurisprudence. Analytical jurisprudence has made a systematic analysis of the legal concept by different thinkers during different periods. Among the positive thinkers, Hart is one of them who very efficiently criticized his earlier positivist theory with an explicit motive to describe the legal system of a society. In his book, The Concept of Law, published in 1961, he has made an attempt to describe the development of legal system from the primitive to evolved legal system. According to him, law is best understood as the union of primary and secondary rules. The primary rules are the rules of obligations, whereas secondary rules are dependent upon the primary rules, which allows the creation, extension and alteration of the primary rules. The difference between the two types of rules are primary rules impose duties, concern actions involving physical movement or changes, whereas the secondary rules confers powers and they provide for the operations which led not merely to the physical movement or changes, but to the creation or variations of duties or obligations. At the beginning, Hart has suggested to imagine a primitive society where there are only primary rules of obligation, which are all customary in nature. That means there is a society without any legislature, courts, or officials of any kind. These primary rules are existed between a group of people who under the obligation to obey it and practice it among its members. But such kind of rules would not make a common standard which can be the basis of the system. For instance, if there is any conflict of opinion between the two individuals, it is hard to determine which one is accurate and prevail in the society, and what would be the procedure to settle this conflict. This is the first defect in the primary rules, which termed as a uncertainty. As Hart correctly pointed out that in the first place, the rules by which the group lives will not form a system, but will simply be a set of standards without any identifying or common mark, except of course that they are the rules which a particular group of human beings accepts. Hart also mentions another two defects in the primary rule. One is the static nature of the rule, as he observed that in a society there will be no means of deliberately adapting the rules to a changing circumstances, either by eliminating old rules or introducing a new one. The third defect was the inefficiency in the primary rules. So Hart realized that primary rules are not at all ultimate in a particular legal system. There is a necessity of such kind of element which can remove this defect of the primary rules as well as acts as the supplement of those primary rules to convert the regime of primary rules in a legal system. According to the Hart, the remedy for each of the three main defects in the simplest form of social structure consists in supplementing the primary rules of obligation with the secondary rules, which are the rules of different kind. Legal system has faced the difficulty due to the uncertainty of the primary rules. So Hart has made a solution to this problem by providing a new secondary rules which has a binding effect named as rule of recognition. This rule can determine which rules are binding by referring to this rule about the rule which Hart called the rule of recognition. The rule of recognition removes the uncertainty of the primary rules, and it distinguishes other rules into two categories. One is the rule of the group, which is supported by the social pressure that the group exerts, and another is the rule of the other than the group. The second kind of the rules are not supported by the organized social pressure rather than informal social pressure. On the other hand, the first category of the rule has been supported by the organized social pressure. In these ways, the rule of recognition evolves and it enlightens a new dimensions in the pre-existing legal system to a new legal system. Hart has pointed out that every legal system has contained one and only one rule which set out the test of validity of that system. That means it's the rule about the validity of the other rule, that is the primary rules. In any legal system, rule of recognition defines the common identifying test for the legal validity of that system. A particular rule can be treated as valid and fit in any legal system when only it has fulfilled all the necessary criteria provided by the rule of recognition. So, the rule of recognition is a rule which points out how to recognize a particular rule as a legal rule. The rule of recognition thus performs the following functions: to establish a test or valid law in an applicable legal system, to confer validity to everything else in the applicable legal system, to unify all the laws in the applicable legal system. According to Hart, the rule of recognition is the foundation of legal system, and it is accepted by both private persons and authoritative criteria for identifying the primary rules of obligation. This includes reference to the authoritative text, legislative enactments, customary practices, and journal declaration of specific persons, or to past judicial pronouncements in the particular cases. In a modern legal system where there are too many sources of law, the rule of recognition became complex. So, it includes constitutional enactments and precedents. So, the sources of law comes under the purview of rule of recognition, as it has power to give validity a particular rule derived from that source. In most of the legal system, the rule of recognition is not stated, but it is shown in such a manner so that a particular rules are identified either by the courts or by the officials. And when a court reaches to the conclusions on the footing that a particular rule has correctly pointed out and termed as a law, it has obtained a special authoritative status and validity. Rule of recognition specifies the ultimate criteria of validity in the legal system, and this rule has been practiced by the officials who have taken an internal point of view of this rule of recognition, so that they can use it as of a standard for evaluating and maintaining the regularity of the behavior of the people. The expression internal point of view has been simplified by the Hart by saying that it is the law that find not only in the lips of the judges, but of the ordinary men living under a system when they identify a given rule of the system. It is naturally used by one who accepts the rule of recognition, and without stating the fact of its acceptance, apply the rule of recognition some particular rule of the system to be valid. Rule of recognition is an ultimate rule which secures the existence of the primary rules, and it's ultimate because when there is no legally limited legislature, there exists an ultimate rule of recognition which provides a set of criteria of the validity to the other rules where one of the rule is supreme. So, what are the objections regarding the rule of recognitions? Let's discuss that. Unlike the other doctrines of the legal philosophies, Hart's doctrine of the rule of recognition is not totally acceptable. It also has been criticized by the other eminent philosophers. Hart describes rule of recognition as the foundation of the legal system, and the content of a legal system is established by the rule of recognition. But some questions has automatically raised which are identified as lacunas in the Hart's doctrine, and those questions are not answered by the Hart. Hart never tell what kind of rule of recognition is, or is it a duty imposing or power conferring rule, or is it a rule practiced by the judges or by legal officials? Though the philosophers like Dworkin, Raz, Finis has opined some different view regarding the Hart's doctrine, Hart suggests for identifying valid rules of the law. And according to Dworkin, most of the rules of the laws are valid because some competent institution enacted them. Some were created by the legislature in the form of statutory enactment, and others are created by the judges who formulate them to decide the particular cases. Here I like to point out that there may be many criticisms in respect of the Hart's theory of rule of recognition, that are, Hart's theory was both under-inclusive and over-inclusive. Hart cannot explain how social practices are capable of generating rules which confers power and imposes duties. Hart cannot explain how disagreements about the criteria of the legal validity which occurs within an actual legal system are possible. As far as the first objection is concerned, Hart's theory of rule of recognition is not flawless. According to Hart, every legal system specifies one and only one rule which specify the content of the legal system. But many philosophers termed this theory both under-inclusive and over-inclusive. Regarding the under-inclusiveness, it is argued that though the rule of recognition characterizes the content of the legal system, but Hart never discloses what makes the rule of recognition a rule. Joseph Raz points out that the most legal systems have several rules of recognition, of which no one is ultimate. For instance, if the governor of the state issues an executive order according to Hart's doctrine, such an order becomes applicable throughout the state, and it is a part of the law of the state, and it is endorsed by the same rule of recognition, which validates the uniformity of all the laws of that state. But that criticize of Hart's theory point out that without establishing the uniformity in the state law, it cannot be said that a particular executive order become the part of that state law. Hart's theory is not only under-inclusive but also over-inclusive. According to Hart, the law consists of all the norms that legal participants under a duty to apply those norms in their official capacity. In his theory, Hart exclusively focused on judges. Rule of recognition, being a duty imposing rules, confer a legal obligation to the judges to apply the same law on different jurisdictions. But Joseph Raz criticized this view by saying that there is no reason to believe that valid norms belonging to one system cannot conflict. Judges are often under an obligation to apply the laws of the other jurisdiction. So, the Hart's doctrine of rule of recognition is under-inclusive. Secondly, the objection raised related to the social practices which are capable of generating rules. According to Hart's doctrine, rules are central in the concept of law in at least two respects. One, pertaining to certain propositional or linguistic entities. The other, to certain kind of practices within a community. It treats certain norms as law only if they comply with the certain criteria, and for that norm to comply with the certain criteria, the notion of the rule of recognition fuses these two senses of rule, being both a secondary rule within a legal system and an important social rule within a legal community. The normative of the law cannot be taken into account without making it clear that whether the rule of recognition is power conferring or duty imposing. As per Hart's point of view, the rule of recognition exists in any system if they are accepted and practiced. From the internal point of view, the rule of recognition needs not to be accepted. Morally, it needs to be followed. The rule of recognition is a social rule because it has the content of certain social facts as well as it is a particular kind of social practice. According to Hart, the social rule account captures the nature of the rules of recognition in the legal system. But in his theory, he focused on the conventional social rules, which includes rule of recognition also. And it is also used to evaluate the validity of norms and behaviors falls within their purview. But Ronald Dworkin rejected the social rule views for the law and for the social practices. It is that insist that judges in reaching conclusions about the legal validity must be operating from the premises about where there is a moral duty to do. He is of the opinion that mere inclusion of social fact is not make a rule social. A rule can become social in nature when most of the members of the group accepts that rule. On the other hand, normative rule provides reasons for the actions and only they can confer the power and impose duties. So, according to Dworkin, secondary rules are not social in nature, they are power conferring and duty imposing based on more principles. Thirdly, according to Hart, the secondary rules derive their content from the consensus. But when there was a lack of consensus over a matter, then disagreements comes into picture. The best example for this, the clash between organalism and constitutionalism. While the interpreting the Constitution, for instance, the interpretation of the provisions of the US Constitution, the interpretive methodology was followed either according to the original understanding or intentions of the framers regarding any provision of the Constitution or according to the understanding of that provision in the right perspective, cultural and social background. So, the disagreement arises relating to the adoption of the interpretation of the constitutional provisions. Dworkin's arguments for the disagreement runs as follows. There is not a rule of recognition that satisfies the condition that Hart sets out the social rules, since there is often a controversy over what criteria is necessarily to be used in determining the criteria of a legal validity. According to the social rule model, a rule of recognition is a social rule, and social rule is one which the members of the community are agreed upon. Hart applies that all the disagreements which Dworkin takes as an evidence that there is no rule of recognition that is agreed upon are better interpreted as disagreements in the application of an agreed upon rule. Dworkin has pointed out that whereas the rule of recognition can determine the dispute over the criteria of legal validity, in this respect of organalistic method is the best way to do this, because the legal validity should be understood on the basis of the moral principles, not on the basis of social facts. It is the drawback of the Hart's doctrine that he cannot explain how disagreements about the criteria of the legal validity which occurs within the actual legal system are possible. Now, in spite of these objections, Hart's doctrine of rule of recognition has credibility to apply in the modern legal system. In this part, I am trying to give a solution that how this criticism can be overcome and the rule of recognition has become the foundation of the modern legal system. I am suggesting to apply the rule of recognition with proper planning and arrangement. so that I can easily respond to the objections as well as eradicates drawback of the secondary rules. So, necessarily is of the proper arrangement of application. In the above, I am discussing these important objections which has rightly pointed out the lacuna in the Hart's doctrine. The first objection is the under and over inclusiveness of Hart's theory. My suggestion is to identify the rule of recognition in such a way that in any modern legal system where there is more than one legal authority and a conflict arises regarding the application of the rule, which authority prevails, then the two rules should be part of the one system, where they are created in accordance with the system's constitutional order and their application should be regulated by such constitutional order. In the case of over-inclusiveness, if the two enacted rules to be the part of the same system, they must be created from the power conferring provisions of that constitutional order. Hart's theory is unable to characterize accurately the content of legal system. So, the second objection raised related to the normative of the legal system. The normativity of the system can be taken into account by making a proper arrangement so that the persons who are authorized by the legal institution having moral legitimacy can act in accordance with the norms. It is not necessary that they have the power to confer the rights and obligations, whereas the necessity is to look into the matter with a legal point of view. The legal point of view can hold the norms, which is the basis of the system, and the legal institutions may generate the moral obligations to obey. The third objection has pointed out the difficulty faced while interpreting the Constitution. This can be overcome by making an institutional arrangements on the basis of the reason which the framers had possesses. This arrangement is to be adopted by the system constitutional designer to point out which interpretation would be fit to harmonize those reasons of the framers. The disagreement in the interpretation arose due to the lack of consensus. Thus, the content of the rule of recognition are inconsistent with the consensus, but generally a consensus right exists in every legal system. So, the consensus is taken into account by applying proper interpretive methodology to cope with the problem faced by the system. In the concluding remarks, Hart's contributions towards the legal philosophy were very much considerable. He suggested the rule of recognition are linguistic entities that designate what the primary rules of the system are, but in the many occasions his theory denotes different meaning of the phrase rule of recognition, which leads to confusions and objections. Though Hart's doctrine has been criticized in some aspects, but the positive side of this doctrine is that none of the philosophers did not deny that law is either founded on the rules or that the notions of the legal authorities and obligations are rule-based concept. No one is proposing to return to Austin. It is not difficult to imagine a normative system in which something like rule of recognition is crucial, but the nature of this rule of recognition that it sets out the criteria of validity is challenged by the critique. So, the requirement is to identify the rule of recognition as an element of the system, constitutional structure with the proper arrangement so that I can guide and organize the behavior of the legal officials through a specifications which each has to apply in that system. as well as it should be identified with all of the norms creating and applying the part of this arrangement. Now, if the question arises regarding the existence of the rule of recognition in a modern legal system, then it all depends on what is the rule of recognition is. Generally, a well organized modern system operates with settled rules of explicit formal change and also with the rules that frame and facilitates informal change with argumentation. So, if we consider rule of recognition only as at least for the validity of a particular system, then it exists. But if we consider it as a duty imposing convention among the officials, then it does not exist, as it cannot properly characterize the content of the legal system. And finally, we take the rule of recognition to be constituted by the norms creating and applying the provision of the system, constitutional framework, then I think it might exist. So, I thank you for your time and attention. I look forward to our next session where we will continue to explore the fascinating concepts of jurisprudence together. Thank you.